Hi, my name is Mark Biernath. I'm an estate planning attorney here in the Atlanta area. In this section, we're going to focus on who are the individuals that are involved in a guardianship. Everything from the petitioners, the proposed ward, the proposed guardians, the attorney that's appointed to represent the proposed ward, as well as the possibility of a guardian ad litem being involved, and an independent medical examiner, as well as the court and the clerks. So let's look at who all the people are that are involved in this, and this will kind of let you know why it costs so much. And this is even if you do not hire an attorney. If you hire an attorney to help you with this, add their fee to this here. But there is the proposed guardian or conservator. So usually that's the person who's filing the petition, but it doesn't have to be. I've had one situation where a lawyer filed a petition of guardianship on behalf of their client, but did not want to be the guardian or conservator, and so the county guardian was appointed. There's a proposed ward. This is the individual who you want to have declared incapacitated. And there's the petitioner. Oftentimes the petitioner and the proposed guardian are the same person. Then there's an attorney appointed for the proposed ward. You do not get to go shopping for this person and pick somebody who's going to do what you want them to do. This is somebody that the court will appoint to represent your child. Their job is to communicate with your child if that's possible. And if it's possible, if your child communicates what they would like to have presented at court, their job is to present that. So if your child tells this attorney, I do not want nor do I need a guardian, that attorney's job is to present that information to the court. Now, that attorney might determine that a guardian ad litem would be appropriate. A guardian ad litem's job is to determine what's in the best interest of the ward. So it's two different roles. Now, for lawyers, our ethical guidelines kind of give us some guidance if we have a client who has diminished capacity or is unable to communicate and effectively assist. And that's where the lawyer is then permitted to basically propose what they think is in the best interest of this individual. So if you have a child who's unable to communicate or anything like that, the attorney that the court appoints will act a lot like a guardian ad litem. But understand the two are actually different responsibilities, and that is, whoever the petitioner is, that is your responsibility, to present clear and convincing evidence that the person needs a guardian. So, of course, involved in this is the court, which consists of both the judge and the clerks. The clerks are an integral part of guardianship conservatorship. Do not walk into court and piss off the clerk, because you will be dealing with that clerk for as long as that clerk has a job and as long as your ward needs guardianship. You will have more contact with the clerk than you will with the judge. So do yourself a favor and start off on the right foot. Don't go in there and, get all pissed off, because you don't know who was just in there before you walked in there. Give them a break. They might be having a bad day that day. Just roll with it. And they might tell you conflicting things at different times. That's okay. We all sometimes make mistakes. So, and then the independent examiner, that is this doctor, psychologist, social worker that's appointed to make an evaluation. So because of all these different people that are involved, the costs are fairly significant. Most courts have flat fees for the independent examiner, for the attorney, and for the guardian ad litem. They also have set fees for what that court's filing fee is. The filing fee is usually set by the superior court judges, and the probate judge doesn't have anything to do with that. They just, they're responsible for collecting the fees. I've had it in one situation where the attorney that's appointed for the proposed ward was actually allowed to bill hourly, and that is a problem because you have no control over how much time they spend on this. And the court will have some oversight, basically the court saying, is it reasonable or not? a very straightforward matter for a child with a disability that's turned 18, has had a lifelong disability, that should not take hours and hours and hours to make the proper determination of representation in court. Whereas mom in the nursing home with a complex diagnosis and complex estate matters, that would warrant more time, and so it might cost more. So again, a phone call to the clerk before you file will, that would be some information you'd want to know. Does the attorney that gets appointed for my son, is that a flat fee or is that hourly? Because if it's hourly, you're going to want to make sure everything's buttoned up. And that may be a reason why you'd want to hire your own attorney, because then your attorney can hold them in check and they don't run up your clock. However, you're paying your attorney. So kind of hard to decide there, but that's one thing that I would look at. And I don't know what this county does. Do y'all know here in this county if it's a flat fee?
Most of the time it's a flat fee.
Okay. And usually it's about $150. Does that sound about right? So, when you add it all up, usually it comes out to about $600, $650. Then, whatever photocopies they make and whatever mailing they have to do will add to that. But the $900 one involved the hourly attorney.
So in this section, we took a closer look at who are all the people involved in a guardianship and how they're going to be involved in your life or the life of your loved one as long as the guardianship or conservatorship is in place. In the next section, we're going to take a closer look as to what is required to establish a guardianship or conservatorship here in Georgia.